Good evening, Justice O'Connor. My name is Jordan Speed, and I'm from Wichita, Kansas. How does the Supreme Court decide when a search and seizure is unreasonable and when it is reasonable?
Well, it's a vague sort of a standard, as you well know. What's reasonable depends very often on the circumstances in the particular case. The Supreme Court, in effect, has determined that if a search of a suspect is unreasonable under constitutional standards, then the evidence cannot be admitted against that person in any criminal proceeding against the person. Now, you know, many countries around the world don't follow an exclusionary rule. That's called an exclusionary rule, where you can exclude that evidence from any trial proceeding against the person that the state is trying to prosecute. And that's rather a dramatic limitation on evidence that can be used by the state against someone. And many countries don't do that. So Great Britain did, and the United States has done that, and I guess Australia to a degree, and other common law countries from the British system. But not everybody in the world thinks that's a good system. But we do, and we have this exclusionary rule. So deciding whether a particular search or a seizure of some kind of evidence to use against someone in a criminal proceeding requires judges at the end of the day to make a determination whether that particular seizure or search was reasonable. Well, what's reasonable? You have arguments on both sides probably, but it depends on the facts in that particular situation and whether there are enough circumstances and facts that are objective that it adds up to some kind of reasonable suspicion that would justify admitting the evidence into a trial and using it in a criminal proceeding. And there's no hard and fast guide. Judges who sit in criminal cases get used to these questions and get used to having to answer them in case after criminal case. So I don't know what guidelines to give you, but they tend to want to try to find some facts, the judge does, that would indicate that this is the circumstances and facts add up to some kind of reasonable suspicion sufficient to justify letting that evidence in.
Good evening. My name is Alex Nunez Thompson, and I'm actually from here in Phoenix, Arizona.
Oh, you are? From a local high school?
Yes.
Good.
My question is, I have two actually. In general, do judges agree on what it takes for the police to establish that there is a probable cause? And how do judges learn how to make good judgments about when to issue a warrant?
Well, it's like anything else. It takes a little practice, I suppose. First of all, you can assume that the judges have gone to law school, that they've passed, that they've taken a state bar exam and they've passed. And you can assume that they've practiced for a time, or they wouldn't already be judges. And you can assume that most of these judges have had some experience already on the bench trying to answer these very questions, because they come up time after time in criminal cases. And it's kind of a combination of learning, study, and experience. And most judges end up serving, as I did for some years, in a criminal court, hearing criminal cases day in and day out. So you begin to get comfortable, if you will, in what you need to ask and what you need to know in order to determine that, yes, for this piece of evidence, there is reasonable suspicion, and we think that it was reasonable under constitutional standards for the police to have it and to use it against the defendant.
My name is Addison Marshall, and I'm from Jonesboro, Arkansas. And my question is, what is the importance of requiring the police to have probable cause and having an impartial judge to sign a warrant?
Well, when our Constitution was written, you know, at first it didn't have a Bill of Rights. You know that. It was a Constitution that told us how we'd have 3 branches of government, and we had a president, and it said something about how the president would be selected. And we had a Congress with 2 houses and how they would be formed. And we'd have the 3rd branch, the judicial branch, and the judges would be appointed by the president with advice and consent of the Senate. Now, that was the sum and substance of the original Constitution. And it dealt some with the powers that each branch would have. But when it was presented to the states to see if the states wanted to ratify it, many people in the states thought that it needed some protection for individuals, that it needed some kind of a Bill of Rights, they called it. And it became clear that some states, not enough states, were going to ratify it unless we got a Bill of Rights. And it ended up being the first 10 amendments to our Constitution. That's the Bill of Rights. And it was intended to try to add some protections for individuals, because the Constitution originally didn't do that. And so the 10 amendments, the First Amendment, as you know, dealt with freedom of speech and assembly, number 1, and then it deals with freedom of religion, and then it deals with the concerns that we're dealing with today, protecting people in their homes and in their private lives from unreasonable violations by authority on behalf of the state. It wanted to protect individual citizens, and that's how the Constitution finally got ratified, because they produced a Bill of Rights and then they got the necessary number of states to approve it, and we became a nation. Well, of course, the language in the Bill of Rights is pretty general. What does it say? No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny any person the equal protection of the laws. Well, those are grand-sounding general principles, but when it comes right down to it, when is someone deprived of liberty or property without due process of law? That's where these questions start coming in. What if the police say, we suspect you of stealing something and we're going to go in your house and search it? Just generally, maybe not even knock on the door, just go in and start searching. Is that a situation where a court, the judicial branch, would then get in and say, wait a minute, that's not a reasonable action on the part of the police. That deprived that citizen of property without due process of law. Those were the issues that would then come before courts and judges to decide. And they set up 3 branches of government. Of course, every state then adopted a similar system, setting up 3 branches of government and having state courts as well. But that's how courts began to get into these questions in the first place. And through the years, they've developed principles that courts look at and judges look at in making these decisions. And decisions of courts are written down, and they become part and parcel of the law, and people can read them and follow them in the future, and you build up a body of law. by way of the cases that have been decided.
Hello, Justice O'Connor. My name is Anna Lyons, and I'm from Des Moines, Iowa. My question is, what are the democratic values underlying the Fourth Amendment?
That every citizen wants to feel secure and safe in the citizen's own person and property and dwelling and home. I mean, I don't want to be accosted when I'm walking on the street by a policeman and grabbed and searched because the policeman thinks, oh, there's been a robbery in this neighborhood and we're just going to search everybody. We'll search you. Well, that's pretty frightening for a citizen. And I think it's that kind of action that the Bill of Rights was designed to prevent, to make sure that if you're going to be searched, for example, by a police officer, that there has to be some reasonable grounds for taking that action. That's severe. If I'm walking down the street and I have my purse and the police come up and say, well, we've had a theft here recently, now I want to look in your purse and see what's in there. Well, we don't do that. We think that's beyond the bounds of what's permitted, absent reasonable suspicion that, yes, this person I'm talking to was on the scene at the time the event occurred and could well have been involved and could well have had something incriminating in her purse. And we've examined the evidence and talked to people, and we think there are reasonable grounds to search that woman's purse. Well, you have to present those sometimes to a judge and see if the court is satisfied that that amounted to reasonable suspicion, because it doesn't always. And these are where reasonable people can differ too at the margins.
Hello, Justice O'Connor. My name is Chanu Lee.
Chan?
I'm from the Northern Mariana Islands.
From the Marianas?
Yes, sir. Yeah.
How interesting.
Yes, Your
Well,
Honor.
you came a few miles, didn't you?
Yes,
Good.
Your Honor.
Good.
Is the respect for privacy one of the values underlying the Fourth Amendment?
Absolutely. Absolutely. And privacy of the person and your home and your personal property. And that's why we require some standard of reasonable suspicion before law enforcement officials can get in there and start digging around and looking. And we hope that those standards are protective on the right standards of the rights of individual citizens. That's what we try to do anyway.
Hello, Justice O'Connor. My name is David Berman, and I'm from the state of Minnesota. Do you agree with Justice Clark's statement in the Mack case that without the exclusionary rule, the Fourth Amendment would just be a form of words and valueless?
Well, I think that's right. If you don't have a means of enforcing the protections that these amendments are intended to give, then it's kind of worthless. It's just so many words. And the exclusionary rule to say the evidence cannot come in if it violates one of the principles in the Bill of Rights, that's pretty drastic to say the state can't use it unless there was probable cause or reasonable suspicion or whatever it is. I mean, that's a pretty drastic remedy to say, no, you can't use it. And many countries do not do that. The Anglo-American legal system is more protective of individual rights than many legal systems around the world. That's a big step to take, to say no. If you can't meet the standards of reasonable suspicion and so on, we're going to keep the evidence out. Or, Mr. Policeman, if you violated them, we're not going to allow that evidence to come in. That's very drastic in certain cases. But we feel that individual liberty is so important. And it was how we got people in this country to agree to the Constitution in the first place. So it mattered to them, and we believe in them. And I think they've served our nation well. You probably do too. I think it's okay. And that's why we have a judicial branch to try to have people who are qualified to serve as judges and who look at these questions and respond responsibly to the issues that are presented, and who don't modify their standards every time the case comes. They have certain legal principles they're trying to apply, and to apply them similarly in similar circumstances. That's very important.
Hello, Justice O'Connor. My name is Jordan Speed, and my question is, what would you say to the argument that the exclusionary rule lets guilty defendants go free?
It could, if it's employed, and if the only evidence against the person was evidence that under our legal principles should not be admitted against the defendant because it was seized without reasonable suspicion, for instance. It's drastic to say, no, the evidence can't come in, that person's going to go free. That's a drastic step. But we think these basic principles are so important, we are willing to have that result to keep our standards high and satisfied under the Bill of Rights. And I guess it's justified. It has served us pretty well.